Hey guys, Zach Anderson with Valley Estate and Elder Law here to talk to you today about healthcare power of attorney mistakes. We see a lot of these way too often in our business and our practice, and these can be feasibly cleaned up. So, wanted to walk through just a couple of mistakes that I see in healthcare powers of attorney. Let's jump in. The first is HIPAA. If your agents under a healthcare power of attorney are not authorized representatives for purposes of HIPAA, they're not getting your medical information if the provider, the hospital, or doctor's office follows the law. The law is very restrictive. We need to explicitly make our agents authorized representatives for purposes of HIPAA. That's very simple to do, but if you don't do it, you could be in trouble. So that's the first thing. The second thing is a living will. A living will or an advance directive for healthcare is different than a healthcare power of attorney. The living will is probably going to be much more narrowly applicable. Only if two doctors have certified that you're in a persistent vegetative state or something similar in Alabama, each state is going to be different there, but the concept is the same. The living will is going to be a lot more narrowly applicable and deal with end of life situations, whereas the healthcare power of attorney is something totally different. That's just if you don't have capacity. An example might be dementia. You can live a long time with dementia. So that's the second mistake. The third is sometimes I don't see the power to hire and fire medical personnel in the document. I like that spelled out in the document. Without it, might you be okay? Perhaps. I see that not spelled out in the document. I would clean that up and just throw that in there. And the last kind of set of mistakes I see is about diligence in this, what I will just call diligence. The first is agent selection. Sometimes we'll have a person name an agent under a power of attorney, and that person lives 20 states away, or sometimes in a different continent. Well, it's going to be hard for them to go to the doctor with you, help you manage medication, pick up prescriptions, things like that, if their drive to you is 12 hours. So, just some kind of counsel and guidance here. I think in agent selection, I see that kind of messed up far too often. And the last thing is, I don't see what happens if you're married and you name your agent as your spouse, as I have. My spouse is my first agent on everything. My wife is. Uh, I like termination upon divorce language. In other words, this power of attorney is revoked upon my divorce or death. That's going to happen by operation of law. But I just like to spell that out so we don't have, some kind of murky issue if there is a divorce. Nobody plans on divorce, myself included, but we do like to plan for it in the documents just to take one potential issue off the table. These are healthcare power of attorney mistakes that I see. Now that you know them, you can avoid them.